I'd like to call up Ms. Fauzia Viqar for her comments and closing speech. Thank you.
Thank you. First of all, congratulations to Women in Law for their 10 years. Must be a difficult journey considering that the gender perspective that we talk about so much is really absent, and it's a struggle, an uphill battle. I'd also like to appreciate and thank the contributors of the book, Tracing Transformations in Law. Good, insightful book and easy to understand, relatable. I'd encourage all of you to read that. I'll begin with thanking our panelists for 3 very rich, rigorous, and thought-provoking interventions. And what this panel had to offer us was not just simply a discussion of 3 areas of law, but a deeper reflection on how law in Pakistan is evolving, where it is succeeding and where it is under strain. For example, one of the most important insights of Sahar's analysis is the shift from understanding harassment as isolated sexual misconduct to recognizing it as a form of gender-based discrimination. This shift matters profoundly. It moves the conversation away from individual wrongdoings and towards structures of power, exclusion and inequality that shape women's experience of work. And that is a massive shift, because in my everyday life, when I deal with matters of harassment, it's very hard to make people understand the systemic realities which discriminate against women in the subtlest of manners, which is hard for a person, especially a person of the opposite gender, to understand because it is not their lived reality. So having a good law and that law evolving matters a lot. When harassment is framed as discrimination, it is no longer treated as an aberration or a personal grievance. It becomes a question of dignity, equality, and access, anchored in constitutional values under Articles 14, 25, 27, 34, and 37. And I really appreciate the role of the judiciary in invoking all those guarantees of not only constitutional equality, but dignity and inviolability of dignity of a person, as well as non-discrimination in employment, the need to have better representation of women in public spaces, etc., to anchor harassment law in these constitutional guarantees. Importantly, the trajectory of harassment law does not just reflect regulatory access or overreach, but it moves to a paradigm for introducing that enabling and safe workplace. It responds to a long-standing absence, a legal absence. And the 2022 amendments, for which I'm personally very grateful because they're coming in handy every day, they represent a corrective expansion, addressing forms of exclusion and invisibility that had legally gone unrecognized. Here, the challenge has been belated recognition and effective implementation, not restraint. An important point that I culled from reading Sahar's chapter was the evolving relationship between the judiciary and the legislature in shaping this regime. The law is developed through a form of institutional dialogue, sometimes uneven, sometimes contested, but ultimately oriented towards giving substantive content to dignity at work. It reminds us that progressive legal change often emerges incrementally through institutional engagement rather than grand legislative moments. And I'm happy to see that we've had similar examples in, for example, Anti-Rape Investigation and Trial Act of 2021, where the law has evolved through this institutional dialogue, through a feedback loop, not only from the legal community, but the civil society. And it has had incremental improvements like the Rawalpindi rape case in 2013 and the various institutional provisions that were introduced in that as guidelines to the banning of the 2-finger virginity test by Justice Aisha Malik, who is sitting here amongst us, reported in 2021. And now we have other opportunity for this institutional dialogue and this feedback loop. I feel strongly in the Elections Act also of 2017, because the recognition, although belated, is there that the law can help in the citizen. Finally, Nida's chapter, I feel like, brings it all together. It draws our attention to a foundational but often neglected question. How are lawyers formed? And I think she's given us an understanding of how lawyers are getting formed these days and who gets to participate in the legal profession. Her analysis, I feel, of the Pakistan Bar Council legal education rules demonstrates how a framework introduced in the name of quality control has, in practice, raised barriers to access, constrained university autonomy, and standardized legal education in ways that sit uneasily with global best practices. The comparative references from the UK are not calls for transplantation, and I assert that very seriously, because often, whenever something good is done and a best practice is adopted from another country, it is castigated as transplantation, unsuitable to the cultural realities of a country. So she's not calling for transplantation. These are invitations to think in terms of principles about accessibility, diversity of pathways, and respect for academic governance. What is at stake is not merely pedagogy, but the intellectual character of the legal profession itself. And her warning is a serious one, that excessive regulatory control risks producing lawyers trained primarily in compliance rather than critical thought. This again is a very important point, because in my dealings with lawyers on an everyday basis, I see that being translated into arguments, into thought patterns which are essentially discriminatory. And I'll give you some examples, and I think Sahar also mentioned about some of the decisions that have come out of FOSPA. When a prejudicial mindset is talked about, for example, by the vice chancellor of a university, the rest of the university and the lawyers representing them do not understand that it is squarely covered under the law, and it is that prejudicial mindset which ends up in discriminatory practice against a woman, who will end up not getting promoted because of that discriminatory mindset. Similarly, for example, even beneficial legislation such as putting a cap on a woman's ability to contribute under the employee's old age benefit insurance at 55, while seen as a beneficial action so that she can claim eligibility at an early age, and may end up discriminating against her because her ability to contribute for 15 years is seriously compromised, Similarly, Sahar talked about the Prime Minister's family assistance package, made for a good cause, but says that a woman, if she gets married, if she has a job after the death of her husband, when she gets remarried, she has to give up her job, otherwise she doesn't have to marry, So the choice is between her keeping her job or not being able to marry. And that is a difficult choice to make. And the underlying message is that a woman should always be dependent on another man. So now that she has found another man to rely on, the job is taken away from her. I have multiple other examples. For example, recently I came across the practice, not the law, but the practice of denying rent of a building to single women and men. Now we know that this goes against constitutional guarantees of equality, but it is accepted in the name of protection from terrorism, protection from prostitution, without clarifying that those are actions that they are illegal, that should be prevented. But you can't deny an opportunity to a woman, for example, who has come from Karachi to Lahore to rent a building, and that single denial is going to shape perhaps the rest of her life. Important issue to make. Or excessive CCTV monitoring for purposes of sexual harassment in this case. So, I think I should wrap up. Across the three contributions, a common concern emerges: the relationship between law and institutional power. Women's trust in workplace mechanisms, citizens' trust in digital regulation, and students' trust in professional governance are all shaped by law by how institutions exercise authority. Law can either repair that trust or erode it further. Protection can empower, but it can also discipline. Regulation can ensure standards, but it can also silence. What we need now is that to understand that while in some areas, such as workplace harassment, the work of the law has been to catch up with lived realities, but also to understand that particular digital regulation and professional governance has had the effect of pulling the law back into alignment, into non-alignment with constitutional limits, and that is where we need to move. Let me conclude by thanking our panelists for scholarship that does not offer easy answers, but it asks the right questions. These chapters remind us that law is not merely a technical instrument, it is a living conversation about power, dignity, and justice. Thank you very much.